will be in case number 29215, Randy May versus Donich, Neurosurgery and Surgery and Spine. The panel for this argument will be myself, Judge Theodosia, Judge Carr, and Judge Schaefer. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. We do keep track of the time on the television there, but I'll also keep track up here if you let me know how much time you want to reserve, if you're going to reserve time. We have read the briefs and are prepared to proceed if you are.
Thank you very much, Your Honor. And yes, I would like to reserve 5 minutes for
5 minutes, all right.
Thank you.
Like I said, keep track on the clock, but I'll also try to prompt you if you get close and you're wrapped up in your argument.
Thank you very much, Your Honor.
You're welcome.
Ms. May, just as a introduction, Ms. May planned on being here, I believe. She's in a wheelchair and having a very difficult time with construction, most likely around the building. But she planned on being here. She told me yesterday she was going to be here. I'm not sure where she is, but she has kept a very high profile in the case, attending all hearings with the court, including the hearing on the motion to dismiss, which we'll discuss today. But we are here because the trial court erroneously dismissed with prejudice Ms. May's entire medical malpractice case because it improperly found to be defective an affidavit of merit that she submitted that was written by a globally renowned neurosurgeon who wrote the standards of care on the exact procedure that we are alleging that the defendant malpracticed during and caused Ms. May's paralysis. She has entire hemiparesis. She's currently wheelchair bound, and this case was a refiled case, so the dismissal pertaining to the affidavit of merit is with prejudice, and Ms. May's constitutional right to a jury has been taken away from her based on incorrectly applied law, incorrectly applied procedural minutia, which this specific court, the 9th District, has held in law that this court, the trial court in this matter, has made errors and did not follow the law set forth by this court. Now, the court took evidence that it believed was evidence that it shouldn't have in a motion to dismiss. The trial court is confined to the allegations in the pleadings. This quote-unquote evidence that the court took was in the form of the opinions of defense counsel, that there were more medical records that needed to be reviewed by our expert in forming his opinions for the affidavit of merit. It took as fact and evidence unsubstantiated internet printouts that were misrepresented, misstated as to the contents of those printouts from the Florida Board of Medical Licensing. Yes?
Can I interrupt you just for a second?
Yes, please.
In regard to the motion to dismiss, I know your argument is that those matters should not have been considered because anything outside of the complaint you should not consider.
Yes, Your Honor.
Of course, their reply to you is, well, you didn't object. And I know in your reply you indicated, well, we said it was improper. But I guess what I'm wondering is, could an argument be made to acquiesce to the procedure by submitting your own evidence?
I don't believe so, Your Honor. I know that there is case law that says that, but we were quoted in our brief as saying the court must confine their opinions to the matters in the pleadings. The failure to convert it to a motion for summary judgment prohibited us from filing a motion, 56F motion, so we should have more time, gather more evidence, do a deposition of our expert, find out specifically what's going on, get an affidavit from him. And the failure to permit us to do that, the failure to convert this motion to dismiss into a motion for summary judgment, there was no ability to acquiesce because we didn't have the time or the information in order to combat it. The defense kept throwing affidavits of their own attorney at the court, which never should have been considered. We reminded the court that they can't consider these. And even if we did not say you need to convert this to a motion for summary judgment, the case law, as indicated in the briefs, mandate that the court itself needs to make that decision and provide the party against whom the motion is filed with notice that it is doing so and permit that party to gather evidence. The main reason for this rule is that you can't have evidence in a motion to dismiss. It's whether or not the pleading is sufficient, which it was. And the only reason that the court on the original affidavit of merit that was filed with the original case, which was litigated, only dismissed because we had trouble getting an expert deposition because of the intense schedule of our expert, was fine. they fought us on this in the first filing. The court specifically stated the numerous reasons why Dr. Robert Levy's brief hiatus from the practice of medicine is not anything that would disqualify him as an expert. The court stated in motion practice that he was extremely qualified, that he'd been engaged in the clinical practice of medicine for over 37 years, that he's licensed to practice at the time in 3 states, that he's performed more than 1,000 cervical spinal cord stimulator procedures, the exact same procedures that were done here in this matter, that he's previously consulted with the company that manufactured the device implanted in the plaintiff during this procedure. He helped design it. He writes the literature that's given to physicians during instructions on how to perform these procedures. At the time of when we were debating this affidavit of merit situation, he was still consulting with these companies, speaking at international conferences, universities, hospitals.
Counsel,
Yes.
the other side though is saying, well, the court is not bound by a previous ruling that it made in a case was dismissed, so it doesn't matter anymore.
And I agree that they're not bound by it. I completely agree with that statement. Once a case is voluntarily dismissed, the court's not allowed to consider that ruling. However, and in case law that was given, the court's not allowed to consider anything, but they did. The court considered all of the evidence that they put forward. So it already broke its own rules by saying we can't consider some of the evidence outside of the complaint, but we can consider what the defense submitted in the form of opinions of their counsel. And it's very important that the first affidavit of merit and the second filing, the original affidavit of merit, the trial court said that was deficient because defense counsel said there were relevant medical records that this doctor needed to review. That was their ruling. That because there were additional medical records subpoenaed during the first filing, that during the second filing, when that affidavit of merit was submitted, that Dr. Levy didn't review these unidentified, unsubstantiated, and not even in the record, in the appellate record, medical records that were concerning Miss May in some unknown capacity. The defense is so thorough with their subpoenas that they subpoenaed her gynecological records in the first filing, which had nothing to do with her surgery, and then submitted an affidavit saying, well, there's a lot of other medical records that we got that Dr. Levy needs to review.
So was there any dispute that the doctor's license had lapsed, I guess, or was not in effect at the time he filed the affidavit?
The second filing?
Yeah, when the affidavit was prepared, is there any dispute that his license was not?
No, there is no dispute, because that affidavit of merit was prepared in 2016. He was licensed to practice medicine at that time and extremely highly qualified.
So at the time he prepared his affidavit, you're telling me he was licensed?
Yes, he was. The first affidavit, there is no, not only was he licensed in 3 separate states at the time. This gentleman, I could spend my entire 15 minutes of argument just telling you how qualified Dr. Levy is to testify in this case. And what the other side...
Not talking about the refiling.
The refiling, yes.
Okay.
The affidavit of merit that we first filed in the refiling was notarized back when the first filing was made. There was no challenge to the affidavit of merit at that time because he was licensed to practice medicine on the date that it was notarized in 3 separate states. And then the court, the only reason the court said that original affidavit of merit was deficient is because of defense counsel's opinions. That's all, opinions in an affidavit that he needed to look at other medical records. And that's in the court's order. They specifically state that there were other medical records that he needed to review, and that's why they disqualified the first affidavit of merit.
Counsel, I don't want to put words in Judge Teodos's mouth, but I'm kind of concerned that you two were talking about 2 different things. Maybe Judge Teodos was talking about the 2018 affidavit, where the allegation was that he was not licensed.
Understood. And this is confusing because the trial court noted the wrong order of the affidavits in their opinion. There was the first affidavit of merit, which was filed in the first case. There is no dispute that he was licensed in 3 states and highly qualified to submit that affidavit of merit in the first case. In the second case, we refiled that same affidavit of merit. That affidavit of merit was found to be deficient because of these other unidentified, unfiled medical records that were relevant because of the opinions of counsel. Then we sent another affidavit to Dr. Levy. He signed it and filed it. At that time, he was on hiatus from practicing medicine. He believed his license was active. We don't have any competent, credible evidence to say otherwise, because there are, and this is why the problem with the unsubstantiated Board of Medicine websites that were printed out by the defense, because they didn't quote the whole thing. And we put this in our brief. His actual designation was delinquent/active. But they didn't put that. They just put delinquent in their motions, and were so apparently convincing to the trial court that the trial court thought that he was suspended, which is what they wrote in their in the trial court's opinion, which is wholly incorrect. He was never suspended. It was delinquent/active, and what we believe happened, and this isn't in the record, but what we believe happened was that he was chief surgical officer at the Marcus Institute of Neurosurgery. He designed it. He was the director. He was on the board. He ran that hospital and designed it. I have no doubt that the gentleman who's that busy has his staff put through his licensing requirements. We believe that there was a failure when he left that hospital for him to take over that job to submit his licensing requirements.
All right, I'm going to pause just for a second, the clock, because you're at 4 minutes and 50 seconds.
Understood.
You said you wanted to, you can continue if you want, I just want to let you know where you're at.
I just wanted to say one more thing before I step down.
I'm going to start the clock again.
Understood, and that's fine. There is no dispute that at the time this case was dismissed, Dr. Levy was in the active practice of medicine with a medical license. It was simply a renewal form that he needed to submit. And when we went in front of the judge on the last hearing, the actual hearing on the motion to dismiss, he was in the active clinical practice and had an active license to practice medicine. There is no dispute to that. So when the case was dismissed, he was active in the clinical practice and had a license. And I will follow up with rebuttal. Thank you.
All right, 4 minutes and 19 seconds, send it to rebuttal. Attorney Funk, you have 15 minutes.
Thank you, Your Honor. Stephen Funk of Retzel and Andrews on behalf of the appellees. As the court has noted, it's well established in this court that you cannot raise arguments on appeal that were not presented in a timely fashion to the trial court, and that if you fail to do that, they're either waived and or forfeited on appeal.
Counsel, but in regard to that, they're arguing, well, we did say that the trial court can't consider these documents or these web searches or whatever outside the complaint, that it doesn't in the complaint. You can't consider it, Judge.
So, if Your Honor, if I could give you kind of a long answer to that, because you have to look at everything in the context of how it was presented to the trial court. So what we had was the original affidavit in 2015 was simply a refiled affidavit that had been attached to the original complaint. It was 3 years out of date. And with respect to that affidavit, they responded by filing a motion for extension of time. The judge at that point denied the motion for extension of time, and in her order of March 29th, she indicates, after review of the affidavit of merit, the court finds it is defective under Civil Rule 10. So with respect to that affidavit, they never argued, either in any of their following briefs or at the hearing, that that original affidavit was not defective. What they instead did was they produced a new affidavit signed in May of 2018. And that was the subject of the second motion to strike was filed. And with respect, yeah, I'm sorry.
Go ahead. No, go ahead.
I was going to say, with respect to that point, they never argued in the trial court that it was not false. In fact, what happened was they had a status conference in which they acknowledged that it was false and asked for more time to cure. So at that point, the judge then gives them more time to cure. And what they argued at that point was that we're not going to rely on the original affidavit, the new affidavit. We're going to rely on deposition testimony. So what was before the court at that point was an argument that they could use deposition testimony in lieu of the admittedly false affidavit. So they were the ones that presented evidence to the court that said, here's this deposition, here are these affidavits. Please rely on the deposition to determine that we have complied with Civil Rule D. So the argument, the point that they make that they say they didn't waive is that they said in a reply brief, reply brief, filed in August of 2018, that the court should confine itself to the pleadings. But at that point, the issue that was before the court was an admittedly false affidavit, and now they're arguing we want to rely on the deposition testimony. That was the issue before the court.
Well, regardless, the point is, they raised, and the whole point is, as you just said, a trial court should not be put in a position of not being able to rule on something because the parties didn't raise it. They
Well, we filed a motion to strike.
Well, I understand, but let's just talk about 12B6. Is that the basic law on the 12B6?
On a 12B6, that would be the law, but on a 12F motion to strike, in this particular situation, an admittedly false affidavit. In that situation, the court then has a moral motion hearing in which the plaintiff's counsel admits on the record that the affidavit is false. And they were not arguing that the affidavit, the second affidavit, the one, Judge, I think you're referring to, the one from May of 2018, was sufficient to comply with 10D. What they were arguing to the judge, and this was the issue that she was presented with, is whether or not she could rely on deposition testimony. And that was what she ruled. So when you look at her order of September 28, 2018, she basically makes two findings. First, she says, okay, is the affidavit, the second affidavit, and on that point, she said plaintiffs acknowledged, and they admitted it at the hearing, that it was false. So I'm going to strike that under Rule 12F. Now the issue is the deposition sufficient to comply with Rule 10D? And on that point, she makes the correct determination that the deposition is not sufficient legally to comply with 10D. She asked her at the oral argument, do you have any case that would tell me that I can rely on a deposition in lieu of affidavit? And they said no. And there was nothing filed in any of the briefs in which that would support
Counsel,
that.
there's so many questions and so many issues. We only have 15 minutes, but
Yeah.
I'm just not sure I understand why a deposition can't be used just because it's not called an affidavit. Isn't the whole purpose of this is so the doctors aren't sued just on somebody's whim, that somebody has actually evaluated and said, this is, a case that he might have violated the standard of care, in my opinion.
Well, there's two arguments on that. The first is the plain language of Rules 10D. It says an affidavit of merit, and it's generally envisioned that it would be an affidavit signed on or around the time that it filed the complaint.
Well, and the reason may be because you haven't even conducted any discovery at this point, and you haven't done depositions, so it sure is a lot cheaper just to require a plaintiff to submit an affidavit than it is to go through a whole deposition procedure.
But the rule is an affidavit. It doesn't say you can file a deposition in lieu
So if
of.
they present more than an affidavit, it's not sufficient to meet the rule.
Well, you have to have an affidavit, and they don't have an affidavit because the affidavit that they relied on, they admitted was false. So they asked that the deposition be done in lieu of an
I
affidavit.
understand. I
So
understand
they-
what happened. I'm just
And
trying
even
to
the
figure
point
it out.
even the point that he said here in terms of at the hearing, he was quote unquote licensed. The point is that he did not at that point ask for leave to submit an affidavit. He was arguing, I want to rely on the deposition testimony.
Well,
And
he'd
that's-
already been shut down with 2 other affidavits.
Well, he was arguing that,
Probably thought he could never get it right.
but
so-
the trial court has to consider what both sides are presenting to him. At this point, he's not asking for leave to present a third affidavit. He's saying, you can rely on the deposition testimony, and under the plain language of Rule 10D, a deposition is not sufficient. This is a deposition from a prior
But you
action.
don't have any case law that says that either, do you?
Well, I have the plain language of Rule 10D.
I understand, but there's no case law that interprets it that says that a deposition is insufficient.
I mean, I don't think it's my burden to present that ultimately when they can't sign the case. I'm arguing that it's unprecedented.
Well, you're the one that moved to strike,
Well,
so it is your burden, right?
our motion to strike was on the affidavit. They then came back and they filed an 18-page brief in opposition that was actually asking for leave to file deposition testimony in lieu of an affidavit. That's July 23rd, 2018. It's an 18-page brief. And I asked the court to look at that brief, because in that brief, they do not argue that the affidavit is sufficient. They had already admitted on the record that it was false. What they're asking the court to do is make a determination that based upon the deposition testimony, they comply with the Rule 10D. And that's the argument that they made, and that's unprecedented. They don't cite any cases that support that. And I would just argue that the court would be violating Rule 10D, and we do cite the plain language of 10D. We do cite cases in which courts have said you cannot deviate and create exceptions to rules that are not created in the rules themselves. So I think that our argument is supported by that. But the second point is that the deposition itself demonstrates that he was not sufficient to comply. In the deposition in 2017, he acknowledged that he was not actively practicing medicine. And this is in our brief. So even if you looked at the deposition, that standing alone would not be sufficient to comply with Rule 10D. So
you're saying, as you said in your brief, then, that the trial court's previous ruling that basically, not basically, it said the exact opposite of what it said in this case is irrelevant.
Well, I think what she said in the prior action, and I do think that it doesn't, it's not controlling. What she said in the prior action was that, yes, he didn't comply with Rule Civil 601D, but I need to make that determination at the time of trial. And that's what she ruled in the prior action. But ultimately,
She also said he was eminently qualified and a brief hiatus was not going to stop her from saying that he couldn't present an affidavit of merit.
but ultimately, that's not the question that was before the court in the second action. The question before the court in the second action was the affidavit that had been submitted was admitted false. So the only issue that the court had to deal with was whether they could use a deposition from a prior action in lieu of the affidavit. That was the issue that the court was presented with. She asked in point blank, give me a case that says I can do that, because the plain rule says that I cannot. They acknowledged that there was no case. She then said, I find under Rule 10D that I can't rely on a deposition from a prior action, so therefore I'm overruling the request to do that. And since I don't have an affidavit before the court, and the 60-day period is run, I'm dismissing the complaint. So in that regard, I would submit that the arguments that they're making now about converting it into a summary judgment motion, those were issues that were not presented to the judge at the time. The issue that was presented by them to the judge was, can I use a deposition in lieu of an admittedly false affidavit?
I'm not sure there's any, I could be remembering incorrectly, but I'm not sure there's any case law that says that you have to object and raise the issue that the court has to convert a motion to an essential motion for summary judgment in order to consider extrinsic evidence.
But again, Your Honor, if you look at the
And I'll just for this part
if
too.
you look at the context of this, that would have been sort of completely outside the context of it, because they admitted that it was false. So the court wasn't needing to rely on extrinsic evidence to determine that it was false. They acknowledged it, and they should have, because this is a court of law, and they have an obligation, if they had submitted false evidence, to acknowledge that that's not correct. So they weren't relying on that
But they
affidavit.
wouldn't have had to even talk about that unless there had been evidence considered outside the record.
Well, I think that they, Your Honor, they would have an obligation to bring to the court's attention once
Well, they didn't know this.
well, they acknowledged it. When the issue was raised, they acknowledged it on the record that it was false. So that is not even before the court really on appeal. This isn't a situation where there was a fact-finding hearing, evidentiary hearing, in which the court had to determine whether or not the affidavit was false. This is a situation where they admitted it was false, and they weren't relying
So
on
no
it.
harm, no foul, you're saying, basically.
Well, and I don't even know if there was any harm, because
That's what I'm
once
saying.
you acknowledge that it's false, you say, can I submit what they said was, we acknowledge, Your Honor, that it's false. Give us time to submit to hear it.
Let me, I know
In
you're
which she
on,
gave them the more time.
I want to give the other judges, I apologize to them sometimes.
That's okay, I'm happy to answer your question, because they really hard.
But here's the question I have too. Okay, how does that relate back to the 2015 affidavit, which is before us too? Because your argument there was that that could not be sufficient because the expert had not considered other medical records that had been disclosed and discovered in the last 3 years or whatever it was.
So
I
on
don't
the
understand how you were able to do that on a motion to strike or a motion to dismiss either, because you're still talking about extraneous evidence.
So the 2015 affidavit on its face was the fact that it was from 3 years ago.
What does that matter?
Because I think that when you file a complaint, you need to have an affidavit that's consistent with the time that the complaint is filed.
Well, but the incident happened in 2014.
Well,
And isn't that the only thing you're supposed to be talking about is there evidence of breach of standard of care at the time of the alleged violation?
so in this situation, two things on that. First is, the trial judge, in her order of March 29, says, after review of the affidavit of merit, this court finds it's defective under Civil Rule 10. In their first assignment error, they do not argue that that finding was in error. What they're arguing is that she considered evidence outside the pleadings. That's their first assignment error. They do not argue that the first assignment error was that the order of March 29th was erroneous. On that point, secondly, they never argued in the trial court that the original 2015 affidavit was sufficient. Remember, after she found that that affidavit was deficient, they then did two things. They submitted a new affidavit, which they acknowledged then was false. And then, in their briefing, in the July and August, they asked for leave to have the court allow a deposition to be served. So they never argued that the original affidavit was meritorious.
Well, hypothetically,
Yeah.
if they had argued that, what is wrong with submitting a 3-year-old affidavit if it still relates to the time period of when the alleged incident happened of the malpractice? Why does
Because,
that matter?
because at this point, there had already been, and then this is the point that was brought up, he says that he reviewed the records. It was on its face clear that there were records produced after 2015.
In the
So he
case
could
that-
not have reviewed all the records. So on the face of the affidavit itself, you can tell that it's not sufficient to comply with Rule 60.
We're talking about the case that was dismissed. But it
That's right.
doesn't affect anything or doesn't matter for anything, but it matters for discovery.
Right, and so with respect to but the key thing is, the original affidavit was basically taken off the table in the trial court. She found it was defective on the face of the affidavit. They never argued that it was not defective. Instead, they took 2 attempts. They first submitted a new affidavit, they admitted it was false. They then asked for leave to allow the deposition to serve in place of the affidavit. So to come back later and say that she erred in finding the original affidavit as false is defective, I think it would be an issue that had been waived and forfeited because it was never an argument that was raised below. They asked for more time. They asked for a 30-day extension of time. The judge denied that motion for extension of time, and they are not arguing on appeal that the judge abused discretion by not granting a 30-day extension of time. And then after she made that ruling, they never raised the issue again in the trial court with regards to the original 2015 affidavit. So I hope that answers your question.
Thank you.
Let me just really ask you a quick question.
Yeah, please.
You keep referring to an admittedly false affidavit. Is the admittedly false part you're saying because he said he was a medical doctor in Florida, but that it said, what did it say?
So there are 2 parts of
The
it,
thing that you found on the printout, what did it say? Something on the back.
that he wasn't licensed at the
What-
time.
No,
was
I
the
said,
word?
I'm sorry.
This,
Is that what
Are
you're
you
saying?
talking about-
Is that the admittedly false part you're talking about?
so it's 2 parts actually, 2 parts that are admittedly false. The first is that on May 29th, before a notary public, he swore
He
under
was
oath
licensed in the state of
that he was licensed to practice in the state of Maryland, in Florida.
Right.
That was a statement he made.
Okay.
That was admittedly false, because at the time, he was not licensed to practice before the state of Florida.
That's because of the printout that you found.
Well, it's also because they admitted that that statement was false. At the time he signed it, it was
Because of the
false.
printout that you found.
That was the evidence that we raised to.
That's what you showed to them, to show that your guy wasn't licensed in the state of Florida.
But then when
So
it was,
that's what you showed them, and they needed time to come back and figure out was that true or not.
right, at that point,
Okay, so
but,
that's the admittedly false part. They say they didn't know because you brought this and they don't know.
well, no, the admittedly false part is that he wasn't licensed at the time he signed his affidavit. So that, they acknowledge that he was not licensed at the time he filed his affidavit.
Because of the printout that you found.
I don't necessarily know if it was because of the printout, I think it's just because that's true, that he wasn't licensed.
Okay.
It wasn't because of the printout, it was because it was true, and that's not really disputed. So the second thing, it may have been because of the printout, Your Honor, but I also think that they probably consulted with him and find out if it was true.
We could argue this all day.
That's what I said.
You're out of time.
The second part, though, let me just
Sorry.
finish the answer to the question, then I'll conclude. The second part, though, that they admitted was not false, is that he was actively engaged in the practice of medicine, because he acknowledged that 50% that he was not actively engaged in practice of medicine at that time, or, plaintiffs acknowledged that at that time. So there were 2 parts that were admittedly false. That's why it was taken off the table. Your Honor, I asked that the trial court properly analyze the issues that were presented to her. She found that the deposition could not serve as a substitute for the affidavit, and we asked the court to affirm her decision. Thank you.
Thank you for your argument. Counsel, I'm going to give you 5 minutes. Since
Sorry.
we went over time, and just to be fair to both
And I'm
sides.
just trying to ask more questions.
Yeah, there's a lot to go over here, so
I
I
probably should have
appreciate that.
scheduled this one for an all-day argument.
I appreciate that.
I'll give you the 5 minutes.
So thank you very much. And there's so much to address in what opposing counsel has said. And first of all, I want to address a very serious misrepresentation. Our first assignment of error was the trial court erred by improperly declaring defective the first affidavit of merit of Dr. Robert Levy, which was attached to the plaintiff's complaint filed February 23, 2018, when the court considered, based on unsubstantiated allegations contained in the affidavits of opposing counsel as facts and evidence outside of the complaint. We did appeal that. I'm not sure why anyone would say that when it's embedded in our first assignment of error, that was an improper ruling. And what they're trying to do is shade the assignments of error into a different abuse of discretion standard versus a de novo standard. We never filed a motion for extension of time to submit an affidavit of merit. We filed a motion for extension of time to reply to their objection to the affidavit of merit. That has nothing to do with this. We are not appealing the judge's denial of that motion for extension of time to reply, but that doesn't affect the assignment of error at all. That was an improper ruling by the court to throw away that initial affidavit of merit, which was proper, and rely on unsubstantiated, unidentified medical records in doing so. And something was brought up here that's very important, is the purpose of Civil Rule 10. Civil Rule 10D is to keep frivolous medical malpractice suits out of court. I understand, recognize the importance of that rule, but the problem here is that it does have merit. Someone who is an eminently qualified person who developed the standards of care for this product, who helped design this product, who has 37 years of practice with an MD and a PhD, and has a 150-page resume, says that this has merit. We could have gone out and gotten someone who just graduated from med school to sign an affidavit of merit. Does that change this? Does that change this fact? Because there's law outside of the Ninth that says that the concern of Evidence Rule 601D, which is the crux of everything going on here, because they objected, because in Civil Rule 10D it says that the expert has to qualify under 601D, which talks about licensed to practice medicine, active practice of medicine, X amount of time, and good standing. So 601D is crucial. And this court specifically stated, a literal and strict interpretation of the statute focusing only on the present ignores the historical nature of the inquiry and the true purpose of the statute. It might even permit the testimony of a novice, currently in practice, yet exclude the testimony of an experienced clinical practitioner who is not. It would not serve the purpose of the statute or the ends of justice to exclude the assistance of an experienced specialist whose clinical practice spans decades because he is now retired.
Counsel,
The true...
can we go back, I know we're running out of time, so can we go back to the standard of review?
Yes.
They filed a motion to strike an affidavit, which seems like it should be the motion to file if you have an affidavit that's improper. And so if that is the case, why wouldn't it be an abuse of discretion?
Well, because, Your Honor, that is an improper way to combat an affidavit of merit. And there's case law on that in our brief. And motion to strike only goes 2 counts of a complaint. You cannot use a motion to strike the whole complaint. And, pardon me, I'm looking for my case site, I apologize. With time restrictions, it's in our reply brief.
I understand, I read that. I'm just trying to figure out, though, with the motion to strike, that doesn't strike the whole complaint necessarily. It just says this affidavit is insufficient. Now, I understand the ramification of that may be the dismissal of the complaint, but would that be where the de novo review comes in? With the dismissal of the complaint, not the motion to strike?
Because it's a domino effect. It's still the de novo standard. Because the proper way to do it that they should have filed was a 12b6 motion. They tried to piecemeal it in a motion to strike and motion to dismiss. Just the fact that they worded their motion to get rid of this case as a motion to strike and a motion to dismiss, if you look at the specific caption of their filing, it's a motion to strike and a motion to dismiss. Where does the motion to strike end? Where does the motion to dismiss begin? And it's because they were using the wrong procedural tool and in effect to dismiss the plaintiff's complaint. It's an improper procedural tool and should not affect the standard of review on this case. They're trying to reframe this matter, but we were in excess of compliance of the rule. We were, I don't know, hyper compliant. The rule states that you have to have someone who's qualified to submit these opinions to establish the merit of the complaint. We're not looking to win our case. This case may be lost on the merits. I don't think it will be. I think that the most qualified person in the country saying that this doctor made a mistake is some of the strongest evidence we could possibly have, which is why the defendant doesn't want to get back into the trial court and uses these tactics of mislabeling motions and stating that we didn't make the proper appellate arguments, which we did, in order to keep this case out of court, because this gentleman wrote the standard of care. He is the lead author on the definitive publication as to how to do this procedure so that you don't hurt someone.
And Counsel, you have used your rebuttal time and the extra time I gave you, so.
Thank you very much, Your Honor. I would just close with that this is legally incorrect. To prevent her from ever seeing the inside of a courtroom is morally incorrect. This case should be fought on the merits. It should not be fought on hyper-technicalities and opinions that were outside of the law of the state of Ohio. Even if he was retired, he still could have testified. There's case law on
Now
that.
you're getting back into arguments.
Sorry, Your Honor, I apologize.
Nobody can be
Thank you very
right.
much. And this is, Ms. May did come here, Your Honor, she was a little bit late. because of the
I see
instruction.
that.
And Mr. May as well, thank you.
Thank you both. I want to thank you both for excellent arguments on this matter. We'll take the matter under advisement, give it due consideration, and issue a decision in due course. The clerk of courts will mail you a copy of our decision on the day it's released, and the opinions are also posted on the Supreme Court of Ohio's website. So thank you again for excellent arguments.